My name is Mark Victor, and I'm really excited to welcome you to the Attorneys on Retainer program. I'm the owner of the Attorneys for Freedom Law Firm. And as you know, the Attorneys for Freedom Law Firm administers the Attorneys on Retainer program. It's a program that our law firm created. This video is to make sure that you understand all of the details of the Attorneys on Retainer fee agreement. Now, we call it a fee agreement because we're a law firm. You're entering into a contract with a law firm. That means you are going to be a client of our law firm. I want you to know I take that very seriously. Every client in my law firm is very important to me. And I want to let you know right from the beginning, if you ever have any experience with any member of my law firm that you think is not entirely committed to excellence, falls short of that standard in some way, I'm asking you to reach out to me directly because I want to know I'm entirely committed to improving every aspect of what we do at our firm, how we operate, and the service that we provide to every single one of our clients. So with that said, I'm very honored you selected to join the Attorneys on Retainer program. I know you had many choices. I know exactly what it is you want with this program. I've been speaking to the gun community now for over 30 years. So I'm pretty familiar with what it is you're looking for. So without further ado, I want to get into the fee agreement. I'm going to go through it in great detail because I really want you to understand exactly what it is you're signing up for. It's very important. I also want to let you know that at the end of this video, if you don't understand everything in this fee agreement, if you have any questions about anything, you're going to be presented with an opportunity to check a box that essentially says, look, I still got questions and I want to speak to one of the attorneys at the Attorneys for Freedom Law Firm. No problem. I want you to understand everything in the fee agreement. Just check that box, and what will happen next is somebody from my law firm will reach out to you and schedule a time for you to have a conversation either with me or with one of my lawyers to go through the aspect of the fee agreement or the entire fee agreement, if that's what you want, to make sure that you have a clear understanding of everything. So if you don't have any questions, just check the box that says, I don't have any questions, and we are done reviewing the fee agreement at that point. Okay, let's get into the fee agreement. I got it right here in my hands. This is what it looks like. You will receive a copy of it. It is on my law firm letterhead. It says Attorneys on Retainer, Self-Protection Option Fee Agreement. And the one I've got in my hand says National Self-Protection Retainer Agreement for Legal Services. It's attorney-client privileged and strictly confidential. This is the monthly payment option. First thing I want to point out is it's attorney-client privileged. Every communication you have with my law firm is entirely protected by the attorney-client privilege. What that means is we can't be called into court and asked questions as a witness about things that we've discussed. So no problem there. It's your privilege to assert to keep us off the stand. But in addition, it also says it's strictly confidential. That means we have an ethics responsibility to keep everything about you or any case that arises or any information that you give us, because you're going to receive an emergency information form in your portal. Everything you provide us on that form is entirely protected by attorney-client privilege and kept confidential. In fact, anything we learn about you or your case from any source is protected by the ethics responsibility that my firm follows to keep everything confidential. So no problem there. Okay, dear prospective member, that's you. This document confirms the terms and scope of our Arizona Retainer Agreement. Hereinafter, the agreement for your hereinafter client. Okay, so you're the client. Anytime we see client in here, that's you. For your ongoing monthly membership in the Attorneys on Retainer program, National Self-Protection Plan, hereinafter the program, offered by the Attorneys for Freedom Law Firm, hereinafter attorney. That's us, an Arizona-based law firm. So it's important for you to understand we're a law firm in Arizona. You are contracting with an Arizona-based law firm. I'm going to get into how we're able to travel to other states and represent you if indeed you have a self-defense related incident. But understand, you're making a deal with an Arizona law firm, and that means all of the Arizona rules are going to apply, including the Arizona ethics rules. The effective date of this agreement, hereinafter, the effective date, shall be the date the attorney signs this agreement, which will occur only after the attorney has received confirmation of this executed agreement by client. The initial, and then we leave that blank because there's an initial fee, usually $100, has been paid, and the client has had the opportunity to discuss all terms of the agreement with the attorney. If you check the box that says, I don't have questions, that resolves that issue. If you check the box that says, I do have questions, then we'll set up an appointment. We'll talk about it after we've resolved all that. Then you become a client of the firm. Section 1, scope of the agreement, subsection A. The scope of this agreement is limited to securing the legal services of the Attorneys for Freedom law firm for limited scope legal representation and related costs and expenses in any self-defense legal matter, as detailed in section 3A, and for a discounted hourly rate for attorneys only in any non-self-defense legal matter, as detailed in section 3J. Okay, so remember, there are two portions to what you get as a client of our law firm if you're in the Attorneys on Retainer program. There's the self-defense related legal matter, and then there's the non-self-defense related legal matter. I'm going to talk about both of them separately. Section B. Other than the retainer legal fee as detailed below in section 2A, no additional attorney's fees, costs, or expenses are required for legal representation in any self-defense legal matter. Any costs or expenses necessary for effective legal representation for self-defense legal matters shall be the responsibility of the attorney. That's us. Client remains responsible for all costs, fees, and necessary travel expenses regarding any non-self-defense legal matter as detailed in section 3J. Okay, subsection C. As to all self-defense legal matters and all non-self-defense legal matters, and as required by the State Bar of Arizona, a new binding fee agreement entirely consistent with the terms of this agreement will be entered into between the client and the attorney for any specific self-defense legal matters or non-self-defense legal matters. The new agreement will contain no additional fees, costs, or expenses for self-defense legal matters. As with all legal matters, legal representation is subject to compliance with the rules of professional conduct, including but not limited to Arizona Rules of Professional Conduct, ER, stands for the ethics rules, 3.1, meritorious claims, and then there's a whole bunch of other ethics rules listed regarding conflicts of interest and any other rules of professional conduct as applicable in any other relevant state. Okay, so a couple of things in section 1C. First off, if we're going to actually represent you in a case, whether it's a self-defense legal matter or a non-self-defense legal matter, we're required to do a new fee agreement. This particular fee agreement is for you to become a client of our firm through the Attorneys on Retainer program. But if we're going to represent you in a case, we need to do an entirely new fee agreement for that specific matter. And that fee agreement will be, pursuant to this agreement, entirely consistent with the terms of this agreement. The other part of that simply says we comply with all the ethics rules. Okay, every lawyer is required to comply with the ethics rules, and we absolutely scrupulously comply with all ethics rules. That's what 1C tells you. Okay, moving on to section 1D. Both the attorney and client agree that the primary purpose of this agreement is to reduce and control the costs of professional services for legal representation in self-defense related criminal law matters, associated civil liability matters, and for specific preventative legal education and consultation in these areas. All other expense-related payment and reimbursement matters are incidental to this primary purpose. Okay, so 1D just essentially tells you what the primary purpose of this agreement is. It's for legal representation in both criminal and civil liability matters, and also for some preventative legal education and consultation. This also will include a free admission to our annual conference where I'm going to parade out all my lawyers. We're going to get a chance to meet them and ask them questions. Each of them will present in a specific area of the law to provide education so you're a responsible, competent firearms owner. Okay, moving along to Section 1E. Here's what it says. The client understands this agreement is not an insurance policy or a prepaid legal plan. The client is retaining an Arizona-based law firm for limited scope legal representation in self-defense related criminal and non-self-defense related matters nationally. The client understands that the lawyers at the Attorneys for Freedom law firm are admitted in Arizona. Okay, so 1E is fairly self-explanatory. Let's move on to Section 2, the retainer legal fee. Section A, monthly payment option. A1, the client agrees to pay the initial one-time non-refundable $100 setup fee and at the end of the first 30 days, commence timely payments of the ongoing monthly legal fee in the amount of, now this part is blank here on the copy that I have because if you're just signing up as an individual member of our Attorneys on Retainer plan, you're likely looking at $35 a month. If you're signing up in the family plan, then for each individual member of your family, the cost is $25 a month. If you're in the local family plan, you're probably paying $20 a month. So that amount will be filled in on the copy that you receive. You're going to pay that each month via credit card for as long as client desires this agreement to remain in force. The monthly legal fee is collected in arrears only after the attorney's availability has been provided to the client. As such, each monthly attorney's fee of whatever amount is earned in full to reserve the attorney's availability during the prior month. So what this means is first we provide the availability. You get a month in the Attorneys on Retainer program, and then you pay the monthly amount that covers the previous month. Section 2A, subsection 2. The client may opt to unilaterally terminate this agreement at any time for any reason or no reason at all. The attorney may opt to unilaterally terminate this agreement at any time for any of the following reasons: non-payment of fees, continued abusive conduct to attorney or staff after one written warning, continued abuse of the emergency hotline after one written warning, continued representation of client would violate the applicable rules of professional conduct, or termination of the Attorneys on Retainer program. Any termination of this agreement by the attorney must be provided in writing to the client at least 48 hours before the termination takes effect. In the event the client fails to timely remit either the scheduled monthly payment or the annual renewal payment, the client will have a grace period of 10 days to bring their account current. If the client fails to pay past due fees within the 10-day grace period, the client's status as an AOR member is automatically terminated and all benefits are canceled. Client shall be afforded 60 additional days to re-enroll their AOR membership without re-incurring the setup fee. If the client voluntarily terminates this agreement, the client has no further obligation to make payments to the program, and the attorney has no further obligations pursuant to this agreement. This provision conforms to the requirements of Arizona Rule of Professional Conduct 1.5 as a true retainer, as that term is defined pursuant to the Arizona Rules of Professional Conduct. So let's break this down just a little bit. First off, either side can terminate our deal. It has to be a win-win. If it's not a win-win, I'm not interested in doing a deal, which means it's got to be a win for you as well. If at any time you decide, you know what, I've changed my mind, I don't want to be in the Attorneys on Retainer program at all, for whatever reason, no problem. You just call us, you can terminate it at any time, no aggravation, no grief, no problem. We don't want you in the program unless you want to be in the program. Now, we can also terminate the program as well. I don't know why we would terminate the program. It's possible we could terminate a client in the program. Maybe the client is rude or nasty or calls up and is abusive to my staff, something like that, or constantly calls the emergency line just to test or things like that. Please don't do that, by the way. Something like that, okay, we're going to drop you from the program. But to be very clear here, we will not terminate this agreement for the sole reason that a self-defense legal matter has arisen. We want to represent you. That's what we do at our firm. The last thing we're going to do is drop a client because, oh my God, a self-defense legal matter has arisen. I've been doing these for 30 years. We're excited at our firm if one of these comes up. So I put that in there to make it very clear. We're not going to drop you because something has arisen and now we got to perform. We will drop you if you're abusive to the staff or members of the firm, and you can drop us at any time you like. That's essentially what Section 2A, subsection 2 means. Also, I want that section to be clear. If you miss a payment, no problem. You get 10 days grace period. If you still blow it, you get 60 days to re-enroll. We won't charge you the setup fee. I think that's pretty reasonable. So hopefully you understand that section and why it's there. I don't want people confused about that section. All right, Section 2A3. First monthly payment will be due 30 days after client's non-refundable setup fee is remitted pursuant to this agreement. Such day of the month shall be the due date for the following month and every month thereafter. In the event the initial non-refundable payment is on the 28th, 29th, 30th, or 31st of the month, the due date shall be the final day of each following month. As the monthly payment is made in arrears, it is due in earned when remitted. Okay, I think that's pretty clear. Moving on to Section 2B, the annual payment option. Subsection 1, client agrees to pay the initial one-time non-refundable setup fee and commence timely paying the ongoing annual legal fee in the amount of, now that's blank depending on the program that you've signed up for, that'll be filled in on your copy, and that's per year via credit card for as long as client desires this agreement to remain in force. The yearly fee is an advance earned on receipt, flat fee to secure the client's membership in the Attorneys on Retainer program for the upcoming year. Client is entitled to terminate this agreement at any time with written notice to the attorney. In such an event, the client shall be entitled to a prorated refund of the yearly fee, calculated by dividing the yearly fee into 12 equal monthly payments, then adding the unused months together. Client shall receive a refund equal to the sum total of the unused months. Unused months are all full months remaining for the year, represented by the yearly fee after the date the attorney received written notice of termination from the client. So let me just summarize that. If you want to pay the whole thing up in full for the year and then you decide to cancel, you get a prorated refund of that annual fee that you paid. Section 2B, subsection 2. The client may opt to unilaterally terminate this agreement at any time for any reason or no reason at all. The attorney may opt to unilaterally terminate this agreement at any time for any of the following reasons: non-payment of fees, continued abusive conduct to attorney or staff after one written warning, continued abuse of the emergency hotline after one written warning, continued representation of client would violate the applicable rules of professional conduct, or termination of the Attorneys on Retainer program. Any termination of this agreement by the attorney must be provided in writing to the client at least 48 hours before the termination takes effect. In the event client fails to timely remit either the scheduled monthly payment or the annual renewal payment, client will have a grace period of 10 days to bring their account current. If the client fails to pay past due fees within the 10-day grace period, client's status as an AOR member is automatically terminated and all benefits are canceled. Client shall be afforded 60 additional days to re-enroll their AOR membership without re-incurring the setup fee. If the client voluntarily terminates this agreement, client has no further obligation to make payments to the program, and attorney has no further obligations pursuant to this agreement. This provision conforms to the requirements of Arizona Rule of Professional Conduct 1.5, as a true retainer as that term is defined pursuant to the Arizona Rules of Professional Conduct. Okay, so same language, same terms, whether you pay annually or whether you pay monthly. And then subsection 3, the first annual payment will be due the same day as your non-refundable setup fee is remitted pursuant to this agreement. Such day of the year shall be the due date for the following year and every year thereafter. Again, as the annual payment is made in advance, a prorated amount for each month is earned every 30 days from the day the annual payment is made. Okay, so whatever day you pay the annual fee, that's going to be your renewal date for next year. Subsection C, client agrees agrees to remit the payment of whatever it is pursuant to your agreement per month for 6 distinct purposes. This is why you're signing up in AOR. Number 1, to ensure the attorney's availability to represent the client for any self-defense legal matter as outlined in Section 3A, subject to conflicts of interest, and commenced with a free strategy session on the self-defense legal matter. Okay, so you might be thinking, what's a strategy session? All right, a lot of other lawyers call this an initial consultation. We call it a strategy session. The reason we've changed the language here is because I see an initial consultation mostly as a sales pitch for why you should hire the lawyer, their chance to tell you why they're the greatest. That's not what we do at our firm. It's not what we've done at our firm. Historically, we have always done strategy sessions. What a strategy session is, it's at least an hour long, and it's a very detailed conversation with the attorney. It's going to take about 30 minutes for the attorney to get a good understanding of who you are, what the case is about, what your background is, what your goals are, those kinds of things. And then at least 30 minutes for the attorney to provide back to you a detailed analysis of your situation, what it is you're looking at, reasonable expectations on the case, how the system works, those kinds of things. That's what we call a strategy session. You get that for free with the attorneys on retainer. Okay, Section 2C, subsection 2, to provide legal representation to the client either as a defendant or as a victim in either state or federal court with no additional attorney's fees for any self-defense legal matter as listed below in Section 3. Okay, so that's the second purpose that you're signing up in AOR. So we represent you either as a defendant, or you notice it also says as a victim. That's right. If you're involved in a self-defense incident and say you don't get charged, but there's a bad guy there. That's the nature of a self-defense matter. There's a bad guy that you acted to protect yourself or a third party against. What if they charge the bad guy? We still offer you representation here. We're going to go to court and represent you as a victim. What does this mean? Well, first off, we're going to do everything we can do in our power to try to get that bad guy charged with a crime, hopefully the most serious crime possible. Second, we're going to go to court if the bad guy is charged with a crime and represent you in your position. If the bad guy is offered a plea, we'll represent your wishes to the judge in court about that plea. If the bad guy is moving to sentencing, either because they took a plea or went to trial and lost, we show up at sentencing and make the argument to the judge for whatever sentence you, as the victim, believe is a just sentence. We're happy to do that. We've done this on many occasions. I personally have represented many victims in criminal cases. It's just something we offer in the Attorneys on Retainer program that, to my knowledge, no other program offers. Section C3, to receive legal information and advice concerning topics relevant to the program in a periodic newsletter delivered electronically. So yeah, we put out a newsletter. We'll tell you about sort of new cases that are developing regarding Second Amendment issues at the Supreme Court and sometimes at the lower level courts if we think they're significant, and also to provide you different pieces of advice, legal knowledge, things to keep you safe and a responsible firearms owner or responsible citizen. You don't have to be a firearms owner to be involved in the Attorneys on Retainer program, nor does your self-defense incident need to involve a firearm or any weapon at all for that matter. C4, to provide payments or reimbursement for costs and expenses on self-defense legal matters as outlined in Section 4. So that's coming up. We'll talk about that. Number 5, C5, to have the opportunity to hire the attorney on selected non-self-defense legal matters at a 35% discount of the attorney's usual hourly rate. Okay, so remember, this is for non-self-defense matters. Remember, we're a law firm. We do lots of different things at our firm that don't have anything to do with self-defense cases, right? We have a whole criminal law practice at our firm. We have a civil practice at our firm. I'm going to get into that later in the fee agreement, but that's also another benefit of joining the Attorneys on Retainer program. And then finally, C6, to have free access to the annual conference with the attorney. You're going to get notice of this for the conference. You are welcome to come in person. You get free access to the conference. We're going to do our best to make a very nice conference for you to attend. If you don't want to travel to the conference, then that's fine. we'll have attendance available online as well, but you get free access as an attorneys on retainer client. Okay, the next section of the fee agreement is bold and underlined. The attorney does not accept payment with funds obtained in any illegal manner. The client hereby agrees and certifies that any funds used to pay any fees pursuant to this agreement were obtained solely by lawful means. If someone other than the client pays any fees pursuant to this agreement, the client consents to such payments made on the client's behalf and understands that the payer is not entitled to information about the representation or to direct the representation, period. Okay, first, don't give us illegal drug money or things like that. It's probably not relevant to the attorneys on retainer program, but it's been in our fee agreement forever at our law firm, and so we will assume that you know and will only give us funds that are legally obtained. Also, someone else might be paying on your behalf. They're not the client. They're not entitled to direct any representation or get any information about anything regarding the representation. Section 3, self-defense legal matters. 3A, a self-defense legal matter is defined as a matter that satisfies each of the 3 criteria below. Okay, so this is important. You want to know what we consider a self-defense legal matter? This tells you right here, Section 3A, 1, 2, and 3. As I like to say sometimes, you got to check the 3 boxes for it to be considered a self-defense legal matter. Box number 1, the client has been formally charged or is reasonably concerned about being formally charged with a crime. And as you can see here, that's either a felony or a misdemeanor. Okay, so you don't actually have to be charged, right? I know that charges don't happen sometimes months or maybe even a year after the incident. That doesn't mean that we wait for that to happen before we start representing you. If an incident occurs, you call us immediately. That's when we're on the case right then and there because you are reasonably concerned about being formally charged. So hopefully that clears that up. Also, doesn't matter if it's a felony or a misdemeanor. So that's box 1. Box 2, the client reasonably and in good faith asserts self-defense or defense of a third party as the defense to the charge. Okay, so this one maybe requires a little bit of explanation. First of all, doesn't have to be a valid act of self-defense. That's one thing that's different about our program. We're not prohibited as criminal defense lawyers from representing people who actually committed criminal acts. Why is this section in here? Here's why. I don't want to represent the person who chooses to go rob a bank, at least not under the attorneys on retainer self-defense legal matter aspect of what we do here at our firm. If you're robbing a bank and you stick a gun in a teller's face, sorry, this is not going to be a self-defense legal matter. Also, we don't want to attract people who are intending to go commit crimes and say, I know, I'll join the attorneys on retainer program and then I'll have them represent me with no additional fee. Okay, so that's what we're trying to exclude. What are we trying to include? We're trying to include the responsible firearms owner who did their best to act in good faith in self-defense, even if they blew it, even if it's a bad shoot. As long as you say reasonably and in good faith, hey, Mark, hey, Andy, I tried to act in self-defense. I did my best. Even if we determine, you know what, it's not a valid act of self-defense. As long as you intended to act in self-defense, it's not a problem for us. So hopefully that clarifies Section 3A2, so you get a pretty good idea of what it is we're trying to do with this program. We are interested and eager and excited to represent people who are charged with crimes. That's what I've been doing for over 30 years. Section 3A, subsection 3, I think this one's pretty obvious. The criminal charge arises from events wholly occurring after the effective date of this agreement. So you can't first be involved in an incident, then join attorneys on retainer and expect us to represent you without additional fees. Look, we're still a law firm, we'll represent you, but that's not going to qualify as an attorneys on retainer self-defense legal matter. The entire thing has to arise after you were already a client of our law firm and enrolled in the attorneys on retainer program. I think this is pretty obvious. And we don't calculate that based on when you're charged. We calculate that based on when the incident happened. Because remember, the incident could happen, you might not get charged for a year later. If you joined attorneys on retainer between the time the incident happened and the time you get charged, sorry, it's not going to be covered under this agreement. I want to be crystal clear about that. Okay, Section 3B. Any matter that does not satisfy each of the three criteria in Section 3A above is not a self-defense legal matter pursuant to this agreement. Any matter that arises wholly or partially from any event occurring prior to the effective date of this agreement is not a self-defense legal matter. The date upon which any formal criminal charges are filed is irrelevant and inapplicable to the analysis of whether a criminal charge constitute a self-defense legal matter. Okay, so that's what I just explained. It doesn't go by when you're charged. It goes by when the incident happened. If the incident happened before you signed up, it's not going to be a self-defense legal matter. Section 3C. This might be my favorite section in the whole fee agreement. Here's what it says. Matters not excluded. If a matter otherwise qualifies as a self-defense legal matter pursuant to Section 3A above, the following circumstances shall not operate to deny legal representation pursuant to this agreement. This is the stuff that we do not exclude. Let's go through the laundry list. The assertion of self-defense is ultimately determined to be imperfect self-defense, illegal conduct, or a criminal act. Okay, so I already talked about this, right? As long as you try to act in good faith, in self-defense, even if you blew it, the fact that you blew it and it's actually a criminal act, that's not going to deny us from representing you without additional fees and costs. The act of self-defense involved a negligent, accidental, or unintentional discharge. No problem. This is still included. The act of self-defense occurred while the client was impaired by alcohol or any other drug. The act of self-defense involved an illegal weapon. The act of self-defense involved no weapon or a weapon other than a firearm. The act of self-defense occurred at a place where firearms were legally prohibited. Let me pause on that one. As you know, many states are working very hard to make as many areas legally prohibited as possible. In the wake of the Bruin case, they're trying very hard to designate areas sensitive places. If your incident happens in a sensitive place, it's no problem if you're a client of our law firm enrolled in the Attorneys on Retainer program. The act of self-defense involved a person who was in a domestic relationship with the client. No problem there either. Client did not possess a concealed carry permit or possessed an expired concealed carry permit. The act of self-defense occurred while the client was a prohibited possessor. Act of self-defense was not a threat or use of deadly physical force. Okay, so none of these are excluded. If you're a client of our firm enrolled in the Attorneys on Retainer program and you otherwise meet those three criteria, the fact that one of these other circumstances exists does not operate for us to deny representing you. I think, to my knowledge, we're the only program that can say such a thing. But anyways, that's one of my favorite sections. Section D. This program is offered in full compliance with the Arizona Rules of Professional Conduct. The attorney is also required to fully comply with all rules of professional conduct applicable in any state in which the attorney appears. Okay, so D is telling you, look, we're going to comply with all ethics rules. We have to. We don't have a choice here. Every lawyer has to comply with the ethics rules. We are currently calculated to comply with them all in Arizona. And frankly, they don't differ that much from state to state. But if we've got to travel to your state and be admitted in your state, what this section is telling you is we will comply with all of the ethics rules in your state as well. Okay, this is sort of a no-brainer because any lawyer who operates in your state has to comply with the ethics rules. Section E, given that the attorney represents no state or federal agencies, the attorney expects no conflicts of interest in any self-defense legal matter. However, if there are multiple co-defendants in the same self-defense legal matter who are also the attorney's clients, a conflict could arise. In the extraordinarily rare event of a non-waivable conflict of interest, which prohibits the attorney from engaging in legal representation in the self-defense legal matter, the attorney shall refund all fees remitted pursuant to this agreement. Okay, so what is subsection E talking about? First off, it is extraordinarily rare that we're going to have such a conflict. Most conflicts happen because the entity on the other side of the case is a client or is formerly was represented, was a client. Okay, in the case of a criminal matter, since we don't represent any state or federal agency, the entity on the other side of the criminal case is never going to be a problem for us. But conflicts could arise if there are multiple co-defendants in the same criminal matter. Now, this is only a problem if both of those co-defendants are also clients of our firm. Now, even if that's the case, you noticed in here I read non-waivable conflict of interest. Many conflicts of interest are waivable. What that means is it's not fatal to the case, and so what happens is we have a waiver of conflict of interest that's been cleared by our ethics counsel. We would provide you with that, encourage you to speak to a disinterested third-party attorney so you understand everything. And then if both people say, you know what, I recognize there's the possibility of a conflict here, but I'm going to waive that possibility of a conflict, and we accept that waiver and everything looks good and you understand and you have been fully informed about everything, we can still proceed because both parties have waived the conflict. What's a non-waivable conflict? A non-waivable conflict in a self-defense matter is going to be something like there are multiple co-defendants and it's self-defense, and each person is a client of our firm, and each person is pointing the finger at the other person, saying, that's the person who pulled the trigger, it wasn't me. That's going to be a non-waivable conflict of interest. I can tell you, in my 30 years of practice doing these kinds of cases, this has never arisen one time, nor have we had anything even remotely close to this. But in theory, it could arise. And if it does arise, then we are prohibited from taking any action as to both, because both are our clients. So we can't do anything other than refund the fees. This is just a limitation that attorneys have in terms of conflict of interest. And in my opinion, it's a good limitation. I don't want to be in a position where I have to do something for one client that is adverse to the interests of another client. Probably much to do about nothing, but it's in there and you should be aware of it. Section F, additional criminal charges in the same matter. In the event additional criminal charges are brought in the same matter, along with any self-defense legal matter, the attorney will determine whether the additional criminal charges arise out of the same conduct as the self-defense legal matter. If so, the legal fees for representation on the additional criminal charges will be included as part of this agreement. However, if the additional criminal charges do not arise out of the same conduct as the self-defense legal matter, they are considered unrelated. In such an event, reasonable attorney's fees will be charged at the attorney's normal hourly rate, discounted by 35% for representation as to the unrelated criminal charges. In such an event, the client will be required to deposit a retainer amount into the attorney's trust account. Alternatively, the attorney and the client may mutually agree to an additional non-refundable flat fee for legal representation on the unrelated criminal matter. If the attorney and client cannot mutually agree on an additional fee for legal representation for the unrelated criminal matter, the attorney shall have the right to decline representation pursuant to this agreement. The attorney cannot represent a client on some criminal charges but not others in the same criminal matter. Okay, so what is subsection F talking about? Look, they could be related additional charges or unrelated additional charges. Say you're involved in a self-defense legal matter and you get charged with, say, an aggravated assault, but also say it occurred somewhere where guns are prohibited and you got charged with simply having a firearm at a place where firearms are prohibited. That's a separate charge, and it's not a self-defense separate charge. If you got that charge all by itself, it would not be covered without additional fees and costs as a self-defense legal matter. That should make sense. However, because it arises out of the same situation, we would represent you on both without any additional fees, right? So if you get involved in a self-defense legal matter and it happens at a place that guns are prohibited, you get charged with a crime for simply possessing a firearm, no problem. We're going to handle that without any issue. But say you get involved in a self-defense legal matter and then you get arrested and you got illegal drugs in your pocket. That's an unrelated criminal matter. They could bring that in the same exact indictment. We can still do it, but it's really not included as part of what we're contemplating with attorneys on retainer, at least as a self-defense legal matter. So what we give you the same 35% discount off of our attorney's regular fees that you would get even if you had that standalone charge as an attorneys on retainer member, right? Imagine you're not involved in a self-defense incident and you get charged with simply possessing illegal drugs or a DUI or something. We can still represent you on that, and we're going to give you 35% off of our hourly rate. So we, in essence, blend those two things together. Now, there's a section in here that says, look, if you don't want to pay hourly, we could agree on a flat fee for just that separate charge. We'll work something out. Our intent in such a situation, which frankly doesn't arise that often, but could happen, is to work something out in a reasonable way with the client that still keeps us in a win-win relationship. So that's what Section F is about. Section G, trial court level. The, quote, trial court level, end quote, includes all legal representation commencing from the client's initial contact with the attorney, informing the attorney of the self-defense legal matter through either a dismissal, acquittal, or sentencing. So we're going to represent you at the trial court level. That doesn't mean that we don't do anything before you go to trial. It means everything from the first phone call, right from that initial arrest, if you get arrested, all the way through a resolution of that matter, whether it be by dismissal, acquittal, or you were convicted of something and therefore a sentencing. No problem. I don't want people to be confused about that. Section H, appeals. If an appeal becomes necessary as a result of any covered self-defense legal matter, the attorney agrees to accept the appellate representation at no additional cost to the client. The attorney will continue to represent the client in any retrial after a mistrial or successful appeal. So that section's pretty clear. We're representing you on a self-defense legal matter, which means you're not paying fees or costs. We're handling that, and you wind up getting convicted of something and you want to appeal, we'll handle the appeal. If your case gets reversed, you got to go to trial again, no problem, we'll do that as well. Section 3I, civil defense representation. The attorney agrees to represent the client in the event client is sued in a civil court of general jurisdiction as a result of any self-defense legal matter. In such an event, the attorney will represent the client in their civil defense with no additional attorney's fees, commencing from the client's initial contact with the attorney, informing the attorney of the civil lawsuit through and until either a dismissal, settlement, judgment, or verdict in the trial court. Additionally, as to all civil matters resulting from a self-defense legal matter, attorney shall also be responsible for any additional expenses as detailed in this agreement, including any pro hoc vice fees or travel expenses unless prohibited by the ethics rules in the relevant state. All right, so let me unpack Section I. First off, we're going to represent you in the civil matter. If it's a self-defense legal matter and you get sued, we're going to handle that all the way through a trial, including all the legal fees, costs, and expenses, just like on the criminal side. No problem. You noticed in there it said we will represent you if you are sued in a civil court of general jurisdiction. What does that mean? This excludes things like small claims. If you get sued in small claims court for $1,000 or something like that, that's not going to be covered under this agreement. Sorry. We're dealing with the serious lawsuits. That's what the court of general jurisdiction is. You're being sued in a fairly serious lawsuit. It's going to be over usually some minimum threshold. States will be different here. It could be $1,000, $2,000, $5,000. But it's what I like to sometimes call the big boy and girl court, the court of general jurisdiction, sometimes called the superior court or the district court in your state. If you're sued in one of those courts with a major lawsuit, we will cover it. If you're sued in small claims for some dinky little case, generally they don't even allow lawyers in small claims court, but that is not covered under this agreement. You'll notice in subsection I, this also includes the pro hoc vice fees and travel expenses if we've got to come to your state. Okay, that's pretty self-explanatory. Section J, non-self-defense legal matters. Regarding legal matters that do not qualify as self-defense legal matters, the client shall have the option to hire the attorneys for legal representation arising from conduct occurring after the effective date of this agreement on any criminal charge in Arizona, any felony charge nationally, or to defend any civil litigation matter at a 35% discount off the attorney's usual hourly rate. However, in such a case, client shall remain responsible for all costs and fees, including pro hoc vice fees and all travel expenses. No other benefits beyond the discounted hourly rate shall apply in cases of non-self-defense legal matters. If the attorney agrees to accept representation on a continuing contingency fee agreement on any catastrophic personal injury matter, the attorney shall offer the client a 35% discount off the attorney's contingency share of any overall recovery. The client understands that the attorney will likely associate with local counsel on all contingency matters outside of Arizona at no additional cost to the client. Okay, so what's J about? J deals with this other aspect of the attorneys on retainer program. It's not all about self-defense legal matters because we're a law firm. We're not an insurance company. We're an active law firm that's been in business for 27 years, and we do lots of other things. And so we've decided to offer that suite of services up to you as an attorney's on retainer client. What does it include? It includes any crime in Arizona. That includes misdemeanors in Arizona. But if you're in another state, misdemeanors technically don't apply. And I don't think you would want to hire us at a 35% discount on a misdemeanor case, especially if you're paying the pro hoc vice fee and travel expenses. Probably isn't going to make sense for you. If you really want us to represent you in a misdemeanor in your state, call us. We could probably work something out, but it's not included in the fee agreement here. Also included here is any felony in any state, you get 35% off. So say you're charged with a DUI or illegal drugs or any other case having nothing to do with self-defense, we'll represent you if you want. We want to be your law firm. We give you a 35% off our regular hourly rates, which is a real discount, by the way. Everybody else at the firm pays the regular hourly rates. AOR clients get 35% discount off. Okay, to be fair, I probably give the same discount to friends and family members, people like that. That's what you get, same treatment as an attorney's on retainer client of our law firm. So any felony is covered in any state. You can always get the discount. But remember, you're going to have to pay costs and fees here as well. All you get in this section is 35% off the attorney's hourly rate. Say you get sued for something. Again, it doesn't have to be self-defense related. You could get sued for breach of contract. You could get sued for defamation. You could get sued because you were in a car accident or something that your insurance company's not going to handle for whatever reason. No problem. We can defend you, same 35% off. Say you're involved in a personal injury case. Okay, if it's a small case, it may not make sense to have us do it. If it's a bigger case, we'll do it, and we'll give you 35% off the same contingency amount that we would accept. These kinds of cases are always handled on a contingency, which means you don't pay anything. You probably heard some of these personal injury lawyers say, no fee unless we win your case. Okay, that's what they're talking about. You don't pay anything. We get paid out of the recovery. We take 35% less than we would normally take. So it's really a good benefit for people who are in the AOR program. Again, you're a client of our law firm, and we want to open up the suite of services to you as a benefit for attorneys on retainer clients. Section K, on duty. In the event a self-defense legal matter arises out of events occurring while on duty, acting in any capacity as law enforcement, security, or other protective services, this agreement shall be supplementary and secondary to any other agreement, insurance, or coverage the client has or is provided for legal representation. All right, so if you're a police officer or security guard and you're in the attorneys on retainer program and you're on duty, you get involved in a self-defense related legal incident. If the police department or your union or someone like that provides an attorney, they're going to be first on the case. We'll still be involved. We'll be second chair on the case. If they don't provide anything, then we'll step up and we'll handle it. So we'll just work with whatever agency provides whatever they provide, and we will work with them on the case. That's what K is about. L, attorney is ethically bound not to represent clients engaging in bad faith litigation, including frivolous legal matters, positions, or defenses. As such, the attorney shall be the sole judge of what matters are asserted in bad faith or are frivolous. If the attorney determines any legal matter, position, or defense is engaged in bad faith or is frivolous for any reason, the attorney will either not accept representation or will withdraw from the case. However, if the client's honest recollection of the events giving rise to a self-defense legal matter are sufficient to allow self-defense or defense of a third party to be argued to the jury, the attorney will conclude the matter is not frivolous. Okay, subsection L. All attorneys are restricted from being involved in anything that is bad faith or frivolous. very difficult to imagine how any self-defense legal matter could be frivolous, unless you're lying to us, unless you say, hey, look, I really didn't act in self-defense, nor was I trying to act in self-defense, but I want you to still argue self-defense on my behalf. Okay, that's not going to happen. That's bad faith. But if you say, I honestly tried to act in self-defense, we're going to accept what you said. Unless you tell us you're lying, then we can't do it. So if you tell us honestly, I did my best to act in self-defense, we're not talking about anything frivolous here. If we can bring that case to a jury or get a self-defense instruction to a jury, no problem at all with us. This is calculated for maybe other circumstances where a client wants us to argue something in bad faith or to bring a lawsuit in bad faith or something like that. All attorneys are held to the same standard. We cannot bring things in bad faith, nor can we act on frivolous defenses or things like that. So every attorney is subject to that restriction. Okay, Section 4, costs and expenses. 4A, the attorney shall be responsible for all costs and expenses as reasonably necessary to effective legal representation for self-defense legal matters only. Costs and expenses include the following: court costs and all official fees, witness and consulting fees, court reporters, expert witnesses, investigators, polygraph examinations, DNA examinations, and other scientific tests, fees related to discovery and departmental reports, medical records, transcripts, process servers, messenger services, appraisers, escrow agents, accountants, electronic research, which is usually Westlaw, photocopies, postage, and any other expenses which, in the judgment of the attorney, are necessary to effective representation. Okay, look, I want to have the best possible defense. That's why we would assemble the best possible team. We're playing to win. If we're going to court, we're doing our best to win the case. That's how we get our 5-star reviews and how we have happy clients. That's what we've been doing at our firm for 27 years. At the beginning, it says we may apply for funds from the court. Sometimes the court will sort of provide funds for an expert witness. If you're otherwise indigent, in other words, you don't have a lot of money, even though we have this agreement, sometimes we can still get the court to pay costs or expenses. And if that's an option, we may avail ourselves of that and use the court's money to pay for an expert. But if the court won't pay for the expert that we want, or you can't qualify for that because you're not indigent, then no problem. We handle all these expenses. The long and short of it is you're going to get effective legal representation from my law firm as a client of our firm, and we're going to handle all the costs and expenses to make sure we got the proper team to give you the best defense possible. 4B, scene cleanup. As to self-defense legal matters only, the attorney will pay a cleaner of the attorney's choice cleaning fees of up to $4,000 to clean any biohazardous materials resulting from the self-defense legal matter from the client's residence or vehicle. The attorney's maximum financial responsibility for scene cleanup is $4,000. Okay, I think that's pretty self-explanatory. C, mental health services. As to self-defense legal matters only, the attorney will pay on behalf of the client fees up to $1,500 or 10 counseling sessions for the client's mental health services needed resulting from the self-defense legal matter. Mental health services must be provided by a licensed professional, such as a counselor, therapist, or psychologist. Attorney's maximum financial responsibility for mental health services is $1,500. Okay, just like the scene cleanup that I just went over, both of these things apply only to the self-defense legal matter. D, firearm replacement reimbursement. Starts out the same way. As to self-defense legal matters only, the attorney will provide reimbursement up to $1,000 to the client for expenses incurred to replace a firearm confiscated by law enforcement in relation to the self-defense legal matter. Before the attorney is required to perform pursuant to this section, the attorney must have a reasonable expectation that the firearm will not be returned to the client within 6 months after the matter has been concluded. The attorney will not pay directly for any firearm purchase on behalf of the client or be involved in any transactions related to the purchase of any firearm. The attorney will provide reimbursement to the client upon proof of purchase of the same model firearm confiscated by law enforcement, but will not provide reimbursement for any upgraded parts. The attorney's obligation to perform pursuant to this section is null and void if the client is a prohibited possessor. The attorney's maximum financial responsibility responsibility for firearms reimbursement is $1,000. All right, so this is pretty clear. First, it only applies to self-defense legal matters. Second, we got to be sure you're not getting your firearm back. Third, we got to know you're not a prohibited possessor. Obviously, if you can't possess firearms, we're not going to pay to reimburse you. And then finally, we're not going to be involved in the transaction. You got to get the firearm yourself. We will then reimburse you up to $1,000. Section E also starts out the same way. As to self-defense legal matters only, the attorney shall also be responsible for payment of bail bond premiums up to $50,000. The attorney will provide the described payment directly to the bail bondsman or the courts on behalf of the client. Client understands that the attorney is not a surety for the client. Client understands that the client may be required to post any bail amounts needed in excess of the amount provided by the attorney. Client acknowledges that it is the responsibility of the client to meet any additional requirements necessary to secure the bail bond, including providing appropriate collateral, etc. The attorney shall not be required to perform pursuant to this section unless the client has provided sufficient collateral. Maximum financial responsibility of the attorney for bail bond related fees is $50,000. Okay, so subsection E only applies to self-defense legal matters. $50,000 is the cap. You got to provide the collateral, right? So if we're putting the cash amount to pay a bail bondsman and that bail bondsman says, I need collateral, somebody's home or something like that, you got to be able to put that up. We do not provide the collateral for you. Subsection F, pro hoc vice. Additionally, as to self-defense legal matters only, the attorney shall be responsible for any pro hoc vice fees as well as all necessary travel expenses. Unless otherwise agreed to by the client, the attorney shall personally handle any trial, substantive, evidentiary, or suppression hearings or contested sentencing hearings in any self-defense legal matter. In the attorney's sole discretion, the attorney may opt for any pro hoc vice counsel to personally handle any routine hearings, including arraignment, pretrial conferences, scheduling conferences, case management conferences, status hearings, discovery-related hearings, or stipulated sentencing. Okay, so F describes the fact that we pay for the pro hoc vice fee. That means we're paying to get the local attorney on board. You'll notice after you become a client of Attorneys on Retainer program, we're going to ask for your preference, if you have one, for a local attorney. If you got somebody you really love who's in your state, in your area, you'll tell us, and in an emergency, we will do our best to secure that person, to get that person on our team. If you don't have anybody, not a problem. We have a plan here at our firm on how to identify and interview such an attorney so we can get someone who's an all-star to add to our team. I want somebody who is hardcore criminal defense, experienced, pro-Second Amendment, pro-freedom, somebody who knows the local judges and rules and things like that, who can actually add to the team. I want our local attorney to be somebody who contributes to the team as much as possible. So that's how we select the attorney. Also, if there's small hearings, say the arraignment, which is going to be maybe a 60-second hearing, the local attorney can handle very routine hearings. Sometimes in criminal cases, we have a status conference type hearing where the attorney shows up and says, yes, judge, interviews are moving along, the case is progressing nicely, we'd like to come back in 30 days. The judge says no problem and routinely grants that. We're not going to fly in for that kind of a hearing. But if it's a serious hearing in your case, one that's going to make a difference, some of the things here we have listed that we are going to personally handle, right? Of course, any trial, substantive, evidentiary, or suppression hearings. These are big hearings that make a difference in your case. Contested sentencing hearing, something like that, we're coming in for that. But say it's a misdemeanor case and we got local attorney, we've worked out a deal, and the deal is, you're going to pay a $100 fine or something, and we know that's the sentence. We may not come for that hearing, unless, of course, you really want us to come for that hearing. We're happy to talk about that. That's the part that says, unless otherwise agreed to by the client. So that's our intent. We will handle all the big, substantive, necessary hearings or trials that matter in your case. If they're very routine, show-up kind of hearings, we may very well have the local attorney handle that matter. Section 4G, incidental costs such as scene cleanup, psychological counseling, firearm replacement, and bail are unavailable in any state where such services are deemed insurance or are otherwise prohibited by the ethics rules or law. These payments are incidental to the existing attorney-client attorney-client relationship established by this agreement, the primary purpose of which is for the services of legal representation in court, as well as legal education and consultation regarding self-defense related issues. In certain states, these incidental costs are paid from a third-party owned charitable fund containing sufficient irrevocable funds and established to pay such incidental costs. Such charitable payment of incidental costs is not an advance and is not to be repaid by the client. As such, the attorney has no reason to believe any of these incidental costs are unavailable in any state. Okay, so what is subsection G about? Some of these incidental things can be problematic in some other states, a minority of states. This is why we have a third-party charitable fund, which funds are owned by a third party, not our law firm. They're irrevocable, so they're available at any time. There'll always be sufficient funds in there to pay the incidental costs, and that fund can be used in those states where these types of issues could be a problem. At the end, it says, we have no reason to believe any of these incidental costs are unavailable in any state. And that's true. We have no reason to think that we have any problem here, especially given that we're using a third-party charitable trust funds. They're putting up the money for the incidentals. However, you do note right at the beginning, it says that these various incidental costs are unavailable in any state where such services are deemed insurance or are otherwise prohibited by the ethics rules or law. We're not unaware of the fact that a minority of states are very hostile to programs like this. That's because they're very hostile to firearms-related issues in general. They don't like the fact that competent, responsible adults own and keep and bear arms, and they do everything they can to harass many of these programs, which is why many of the other programs don't do business in many other states. So if it is determined that these incidental costs are either illegal or unethical in any state, well, then we can't provide them in that state. But given that we're using a third-party fund and not the attorney's money to pay incidental costs in those minority of states, we have no reason to think any of these incidental costs are unavailable in any of those states. So hopefully subsection G is clear. We don't expect any problems in these issues, but this is written in a way to deal with the states that are hostile to these kinds of programs. And as far as we know, at least right now, we have no problems with any state offering these incidental costs. Section 5, other provisions. 5A, the client understands that the attorney is currently admitted to practice in Arizona. However, the attorney routinely appears as counsel of record in other states by the operation of that state's pro hac vice rules. The attorney has appeared pro hac vice in many other states on many other criminal matters in both state and federal courts without ever having been denied. As such, the attorney has every good faith expectation that the attorney will be permitted to appear pro hac vice in any state, on any state or federal criminal matter. Indeed, the United States Supreme Court has recognized the pro hac vice aspect of the Sixth Amendment right to counsel of one's choice. See United States v. Gonzalez-Lopez, 548 U.S. 140, 2006. However, if for some unforeseen reason a court denies the attorney's application to appear pro hac vice in a self-defense legal matter, the attorney will secure, at the attorney's expense, substitute representation by an attorney qualified to represent the client in the self-defense legal matter. Okay, so what is this section about? First off, it's true. We have appeared many times in many other states in both state and federal matters. I can't think of a time in at least the last 20 years where we haven't had at least one or two cases in some other state court or federal court outside of Arizona. We've never had so much as a hiccup in terms of being admitted, nor have I ever heard of any of my fellow attorneys who are in good standing with the state bar, as we are, from being denied an application to appear pro hac vice in a local court. Indeed, I put this case in here, United States v. Gonzalez-Lopez. And if you're concerned about this, I encourage you to read that case and see what the United States said as they reversed a conviction without even finding any prejudice, essentially saying the court should not have denied this attorney's pro hac vice appearance in court, and because they did, we're reversing the whole case. I also think it's important to just note, in that case, the attorney was allowed to appear pro hac vice. There was no issue on that, but the attorney was alleged to have violated one of the local rules in court, and the judge said you can't appear any longer. And even under those circumstances, the United States Supreme Court reversed the case. So we feel very confident that we will be able to appear pro hac vice, as we have always in the past, in any of the 50 states, or I should say 49 other states, in the United States without any problem. However, because clients have raised this as an issue, we put this final part in there. In the event we're denied, then we don't just leave you hanging. We will pay for a substitute attorney to represent you who is as qualified to handle the self-defense legal matter. We don't expect that's going to happen, but we put it in there to address your concerns about what might happen if we were not allowed to appear pro hac vice. Okay, Section 5B. Client agrees to timely provide all information requested by the attorney. All parties to this agreement consent and agree that notwithstanding who has actually paid the monthly fee, only the person identified by this agreement as the client is entitled to legal representation. Only one person can be identified as the client per this agreement. Okay, that's pretty standard. Section 6. Ethics obligation. 6A. Client understands and agrees that this agreement is governed solely by the Arizona ethics rules, and that the attorney is bound by and complies with all ethical obligations and standards of conduct as required by the Arizona Supreme Court and any other state's regulatory authority involving matters in other states, including but not limited to: 1. Attorneys required to reveal such information to the extent necessary to prevent the client from committing a future criminal act that is likely to result in death or substantial bodily harm. 2. Attorney will not assist the client or any witness in testifying falsely. 3. Attorney will be required to correct any false statement of material fact presented to a tribunal. And subsection B, attorney cannot bring or defend a proceeding, assert, or controvert an issue unless there is a good faith basis in law, in fact, for doing so that is not frivolous, which includes a good faith in non-frivolous argument for an extension, modification, or reversal of existing law. A lawyer for a defendant in a criminal proceeding may nevertheless so defend the proceeding as to require that every element of the case be established. C. Attorney may withdraw from representing the client as required by Arizona rules of professional conduct. And D. This agreement shall be governed by Arizona law. If any portion of the agreement is held to be unenforceable, the remaining portions of the agreement shall continue to be enforced. The venue for any dispute regarding the terms of this agreement shall be Maricopa County, Arizona. Any and all litigation over the terms of or any aspect of this agreement must be filed in the Maricopa County Superior Court. Both the attorney and client agree that any litigation filed in any other court shall be immediately dismissed, that the filer shall be responsible for all related attorney's fees and costs. So Section 6 basically lays out some aspects of the ethics obligations that we comply with. Every lawyer is required to comply with the ethics rules. I hold our firm to even a higher standard of ethical responsibility because that's the way we practice. But I wanted to lay out for you some of the limitations of what attorneys are allowed to do under the ethics rules. D basically tells you, hey, this is governed by Arizona law. If we get into a dispute, it's going to be handled in Arizona in Maricopa County Superior Court. Section 7, credit or debit cards. Client understands and agrees that this agreement is an ongoing monthly agreement to pay an earned monthly fee to secure the attorney's availability. Client authorizes the attorney to charge such a monthly fee to the client's designated credit card until such time as client notifies attorney to terminate this agreement, or the attorney notifies the client the attorney is terminating this agreement. Okay, so that's pretty simple. We're just letting you know we're going to hit your credit card if it's a monthly matter every month, and you're giving us permission to do that. Section 8, confidentiality, disclosure, third parties, ER 1.8F clause. Section A, sometimes clients may have someone assist them with their monthly legal fee. If the third party has agreed to remit the client's monthly legal fee, client hereby gives informed consent and agrees. 1, that the attorney may communicate with the third party only about the monthly fee. 2, that the third party payer will not be authorized to receive or request any information about the representation representation of the client unless the client gives the attorney the client's express written permission to make such disclosures, understanding that if the attorney makes any disclosures of privileged information, it may waive attorney-client privilege. And 3, that the third-party payer may not direct the representation. Only the client may make decisions about the client's legal matter. Subsection 8B, if the third-party payer fails to pay the client's monthly fee and another arrangement cannot timely be made, this agreement will be automatically canceled as outlined in Section 2, and the client will no longer receive any benefits of the program. All right, so Section 8 is pretty self-explanatory. 9, cooperation. A, client agrees to contact the attorney as soon as is reasonably practicable, either in person or through a third party, in the event legal representation in any self-defense legal matter is necessary. All right, so we don't play any games with who's going to contact or how we need to be contacted. Just get word to us as quickly as possible and we'll spring into action. Section 9B, client also agrees to keep the attorney informed of current contact information, telephone numbers, secure email, mailing address at all times. That seems pretty self-explanatory. C, client acknowledges the best results in this matter can be achieved by the client providing the attorney with full, truthful, and complete information concerning all pending legal matters. Client's signature on this agreement attests that the client has carefully read every provision of this agreement and has had all the client's questions answered satisfactorily. Client also attests that the information the client has given and will give to attorney will be truthful and accurate to the best of client's knowledge. D, if there are any changes in material information or contact information, client will promptly notify attorney. E, client also understands that the client should not use work email addresses, work computers, or public computers, such as at a public library or hotel, or any email account for which someone other than client has access to communicate with the attorney in order to protect the confidentiality of discussions, as email may not be secure on all computers. I think that's pretty self-explanatory. And F, client also agrees to notify the attorney if the attorney should not communicate with the client via email or regular mail due to a risk of interception of those communications. G, client also agrees to appear in court. In the event the client willingly fails to appear in court, the client understands and agrees that the client has 14 days from the date of the client's failure to appear in court to contact the attorney to continue representation pursuant to this agreement. The client understands and agrees that in the event the client willingly fails to appear in court or fails to contact the attorney within 14 days of the client's first failure to appear in court, any obligation of the attorney pursuant to this agreement is terminated and all benefits are canceled, and the client agrees that the attorney may withdraw from representation. Look, if you're not going to show up in court, we can't represent you. If you blow it or you screw up and you don't appear in court voluntarily, remember, this is voluntarily, not you got into a car accident or there was a confusion about dates or something like that. If you blew it and you freaked out and you decided not to go to court, that doesn't mean we're going to withdraw. We give you 2 weeks. Call us. Say, hey, Mark, I blew it. I didn't show up in court. Okay, no problem. We'll handle it. But if you just disappear and you decide you're not coming to court and you're not going to call us, okay, at some point, we're done representing you because we can't represent you any longer. A bench warrant's going to be issued, and that's going to be outstanding until they fine you and drag you back. So don't do that. Section 10, communications and file retention. 10A, the attorney may communicate with the client by facsimile, mobile telephone, and email unless other arrangements are made. Therefore, the client agrees to keep the attorney informed of current contact information at all times. The email address the client provides to the attorney must be one for which only the client is authorized to view the content to avoid waiving attorney-client privilege. Client should be certain that email filters do not block emails from the attorney and that the allowable size of incoming emails is sufficient to accept the attorney's emails with attachments. It's important that the client retains all communications, including emails and attachments to emails. The attorney provides such items to the client as your copy of the client's file. B, attorney retains many documents in electronic format only. These documents may be stored on a remote, secure, third-party server hosted through the internet, i.e. the cloud. If the client requires any heightened security measures for the storage or transmission of electronic data, such as for government clearances, please notify the attorney. C, client agrees to notify the attorney immediately upon the conclusion of any self-defense legal matter. If there are documents the client wishes the attorney to resend to the client, client understands that the attorney will not retain client's file indefinitely. As such, after the conclusion of any legal matter, the attorney may retain a copy copy of the client's file electronically only for 3 years, at which time it may be destroyed without further notice to the client. So it's all pretty self-explanatory. We're going to give you copies of everything. If you lost it and you need it replaced, no problem, let us know. But don't call me 10 years later and say, hey, Mark, I need a copy of your file, because I probably won't have it. The good news is, if it's a criminal case and it's important, it'll likely be in the court file. But just keep us informed. We'll give you copies of everything. 11, privacy policy. A, the attorney collects non-public personal information about the client only in connection with providing legal services to the client. The attorney will not disclose any public or non-public personal information about the client to anyone outside the Attorneys for Freedom law firm, except as authorized by the client or required or permitted by law or court rule. I think that's pretty self-explanatory. 11B, the attorney will not communicate confidential information about the representation to third persons, including the client's family members, unless the client gives the attorney written permission to do so, understanding that such communication could waive the attorney-client privilege. We're very serious about keeping your information and everything about your case confidential. Okay, that gets us to 12, affiliate referral partner disclosure. This section applies to the client only if the client was referred to the attorney by an approved program affiliate or referral partner. By clicking the box indicating the client's approval and informed consent, the client hereby authorizes the attorney to disclose to the affiliate or referral partner only the fact that the client has enrolled in the program and the client's membership status. No other information regarding the client or any legal matter will be disclosed to the affiliate, any referral partner, or anyone else. Client further understands that any referring affiliate or referral partner may receive compensation as a result of their referral. So 12 is about if somebody referred you, they're an affiliate, and they may say, hey, please let the attorney know that they can let me know that you signed up so I get some money for referring you. Okay, fine. You got to check that box. Otherwise, we don't tell the affiliate anything. 13, acceptance. It says that you certify you've carefully read all terms of the foregoing agreement and understand all of its terms. Any questions I had about the agreement have been explained to me by an attorney to my satisfaction. I agree to be bound by all terms of the foregoing agreement and specifically to pay the monthly fee pursuant to this agreement. Further understand that the attorney does not currently represent me in any legal matter as a result of this agreement. If legal representation is needed, I will immediately contact the attorney, who will then execute a new agreement for legal representation entirely consistent with the terms of this agreement. Signed, Mark J. Victor, Attorneys for Freedom Law Firm. And then there's a spot for you to sign and to click that you can confirm you are over 18 years of age. I have now read every word of the Attorneys on Retainer fee agreement to you, but you might still have questions. And if you do, like I said at the beginning, check the box that just says, hey, I want to speak to an attorney. We'll get that message and we'll set up a time for you to talk to one of my lawyers or me to go over the section of the fee agreement that you don't understand. If it's all clear to you now and you have no questions, check the box that says, I get it, I understand, I got no questions, and then you will be a client of our law firm. I want to tell you something about our firm really fast while I got you here, if you've listened all the way to the end of this fee agreement explanation. And I did this because I really want to make sure you understand exactly what it is you're signing up for. But I also want you to understand what the Attorneys for Freedom law firm is about. We're called the Attorneys for Freedom, not just as some catchy marketing name. We're actually attorneys for freedom. We're activists. Every lawyer at my law firm has specifically signed a statement saying that they agree with the principles of the global peace movement that the Attorneys for Freedom law firm has started. What? Global peace movement? Yeah, I want to tell you about it. Are you tired of just being cranky about what's going on in the world? You ready to do something about it? I am. How about you? Check out liveandletlive.org. What are you going to find there? You're going to find the Live and Let Live global peace movement that was founded by our law firm. We've got people all over the world on many different continents who are very serious about doing their best to change the world. They're part of the Live and Let Live global peace movement. Check it out. See what's said there. That's what we mean when we say we're for freedom. We're for freedom on not just the issue of competent adults keeping and bearing arms, but on all issues. You should live your life as the iron-fisted dictator of your body, your property, your money, and your time. That's what we're advocating for. If that interests you, check out liveandletlive.org. Join the peace movement. Add your name to the growing number of people around the world who are essentially saying enough is enough. I want to live, and I'm willing to let other people live however they want, as long as they don't aggress against me, as long as they don't infringe on my right to be the iron-fisted dictator of my body, property, money, and time. All right, I hope I have sort of whet your appetite here, where you'll at least go to liveandletlive.org and check it out. I also encourage you to check out your new law firm, the Attorneys for Freedom. Again, I've been practicing over 30 years. The law firm has been in business now over 27 years. Find out what we're about. This isn't our first rodeo. We're not some new startup. Check out attorneysforfreedom.com. Find out a little bit about your law firm. I hope you will consider us your law firm now. If you have a legal problem and you're a member of our firm now, you're a client, call the firm. And feel free to ask us any legal question. If we can help you, we will. Use us as your attorney. And finally, I want to say, don't call the emergency line with routine questions. That emergency line is actually set up as an emergency line. It sets a whole bunch of things in action. Every attorney at my firm is going to be notified. If you call that attorney emergency line, that means you need action right now. Look, if you're in an emergency, by all means, call the emergency line. We want to handle that for you. That's what we exist for. We need to deliver on our side of the contract. But if you got a routine question, call the regular customer service line. We're happy to answer your questions, no problem. Please don't abuse the emergency line. So that's all I've got for right now. I want to welcome you as a client to the Attorneys for Freedom Law Firm. Thanks for trusting us with the Attorneys on Retainer program. If you do have a problem, rest assured we got your back. Peace.